Thank you very much. And thank you very much for that warm welcome. I have heard that the introduction of a speaker should tell you something significant about him and also make him feel good. And Sally's introduction did just that. We are gathered on a day that is twice historic. On this day, back in history, the Electoral College first elected George Washington president. And Chief Justice John Marshall was sworn in as Chief Justice. Now, no president could match Washington in terms of his historical significance, and no Chief Justice could hope to come close to Chief Justice John Marshall. But the subject of my remarks today, Chief Justice William Rehnquist, indisputably ranks among the 2 or 3 most significant successors to Chief Justice John Marshall. I'm delighted to be visiting you here today at the William H. Rehnquist Center. On my short visit, I've had the opportunity to meet with the university's administration, faculty, and students, as well as earlier this morning, my fellow judges. I've also met with some high school students. And I have a good sense why Chief Justice Rehnquist, throughout his life, was drawn to the warmth and vitality of this part of the country. I also now know why the court lost Sally to Tucson and the University of Arizona. I would like to congratulate the university on its wise decision to establish a center named after Chief Justice Rehnquist to promote scholarly inquiry on the constitutional structures of government. The center links the Chief Justice's name with the legal issues he considered fundamental to liberty in a part of the country that he dearly loved. Now, I know that if he were here today, he might, with the genuine modesty that characterized him, resist the tribute of having a center bear his name. But I also know that he would be quite pleased. Chief Justice Rehnquist had a favorite piece of verse, perhaps derived from this part of the country, from Thomas Gray's Elegy Written in a Country Churchyard. As many of you know, the poem observes, "Full many a flower is born to blush unseen and waste its sweetness on the desert air." The Rehnquist Center, happily, is not one of those. It has already enriched the legal community with fresh insights and perspectives. I'm also honored to be the 3rd person to deliver at the center a Rehnquist lecture. My colleague and friend, Justice Sandra Day O'Connor, delivered the inaugural lecture, and she talked about the important role that the center would play in addressing core constitutional issues. Former circuit judge and Secretary of Homeland Security, and my law school classmate, Michael Chertoff, delivered the 2nd lecture and spoke about the role of judicial independence and judicial modesty in dealing with modern challenges to the rule of law. Now, for my part, I would like to talk more personally about the center's namesake. We now have the vantage point of 3 years and several months since William Rehnquist's passing. During that time, I have faced the challenges of filling the office that he left vacant. I knew William Rehnquist as one of his law clerks and as one of the many attorneys who appeared before him. As I look back on him as my predecessor, my respect for him continues to grow. The history books will record that William H. Rehnquist was the 100th member appointed to the Supreme Court of the United States and the 16th Chief Justice. He served on the court for more than 33 years, longer than all but 6 of the court's justices. During that period, he authored more than 450 opinions of the court, many on the most significant legal issues of his era. As Chief Justice, he presided not only over the Supreme Court, but over the proceedings of the Judicial Conference. He himself was an historian who authored 4 books on historical subjects. The books were remarkably prescient. He wrote a book about impeachment years before he became the 2nd Chief Justice to preside over an impeachment trial. He wrote a book about civil liberties in wartime before the events of September 11th caused those issues to come again to the forefront of the Supreme Court's work. Rehnquist was a student of history, but he would be the first to recognize that neither the long list of his official accomplishments nor the tall stack of honors he received was the measure of his life. I first met William Rehnquist more than 28 years ago. I came to Washington as a recent law school graduate to interview for a clerkship. The initial meeting left a strong impression on me. Justice Rehnquist was friendly and unpretentious. He wore scuffed hush-puppy shoes. That was my first lesson. Clothes do not make the man. The justice sported long sideburns and Buddy Holly glasses long after they were fashionable, and he wore loud ties that I am confident were never fashionable. If his apparel proclaimed anything, it was his indifference to what is conventional in matters great and small. That turned out to be a recurring theme of his life. Justice Rehnquist taught by example, but he did not leave the most important lessons to inference or implication. He bluntly told those of us who were his law clerks that our lives would be shaped by a connected series of choices. And as he put it, how wisely you make those choices will determine how well you think you spent your life when you look back on it. Looking back on the life of Chief Justice Rehnquist, I'm struck by how many of his choices were extraordinarily unconventional, or even if conventional, were made in very unconventional ways. This theme began early in his life. He was born October 1st, 1924, outside of Milwaukee, a descendant of Swedish immigrants. When later in life he was named Swedish American of the Year, his only question was, who came in second? But that remark was surely tongue-in-cheek because he could rattle off the exploits of the full spectrum of unlikely Swedish Americans, ranging from Greta Garbo to Buzz Aldrin to Earl Warren. He researched his own genealogy in connection with the Swedish American of the Year award and discovered that in the 17th century, one of his ancestors, the steward of a wealthy landowner, had been executed for embezzling funds. Early in his life, the young Rehnquist coupled dogged determination with what would become a lifelong attraction to friendly wagers. Some of you may know that summer comes slowly to Milwaukee, and one cold Memorial Day, Rehnquist bet his sister that he could dive into the frigid waters of Lake Michigan more often than she could. He won and got pneumonia in the process. But that did not stunt his love for games of chance. At the Supreme Court, he was well known for organizing a betting pool each year on how deep Washington's first snowfall would be. Moving ahead, Pearl Harbor was a defining event for William Rehnquist, as it was for his entire generation. He entered college shortly after the attack on Pearl Harbor, enrolling in an Army Air Corps program to train meteorologists. The program, however, was canceled within a year. Things in the Army were much like they are today, and it turned out that an Army typist had typed one too many zeros on the order indicating how many meteorologists would be needed. So the extra would-be meteorologists were given a choice. They could go to officer candidate school or enter the Air Corps as enlisted men. In one of his many unconventional choices, Rehnquist chose the route of the enlisted man, saying he was not much for spit and polish. So he ended up at air bases in North Africa during the war. And one lesson that Rehnquist, the son of Milwaukee, always said he learned from that experience was that if you chose wisely where you lived, you would not have to shovel snow for 4 months of the year. Rehnquist used his GI Bill benefits to go to Stanford, focusing on political science. He then made a conventional choice, but in an unconventional way. He decided to abandon academia and become a lawyer. But he did so based solely on the results of a standard aptitude test, which suggested that he had the qualities necessary to be a good lawyer. One of his classmates, Justice Sandra Day O'Connor, said he was clearly the best student in his law school class. A Stanford professor brought William Rehnquist's performance to the attention of Justice Robert Jackson, who offered him a one-year clerkship at the Supreme Court. Rehnquist later explained that he learned an important lesson during his clerkship that came to characterize his approach to legal problems throughout his life. He put it this way: ideally speaking, you never know as much as you should about the particular matter being judged, whether you are a law clerk trying to decide what recommendation to make about a petition for certiorari, or an appellate judge deciding whether to vote to affirm or reverse the decision of a lower court. The crucial question is, when will I know more than I do now? Perhaps it's just my own way of working, but I have always preferred, when possible, to go through one thing from beginning to end, do whatever I have to do with it, and move on. Now, near the end of Rehnquist's one-year clerkship, the Library of Congress received an unusual request from Justice Jackson, asking which United States cities had the most sun over the course of a year. The request, of course, was not from Justice Jackson, but from his law clerk. Rehnquist was trying to decide where to live, and he would do that in a very unconventional way. The list came back. Tampa was first. Rehnquist decided that was too humid. Albuquerque was second. Rehnquist decided that there was too much old money there and that it would be very hard to enter the legal community. Phoenix was third, and Phoenix it was. At the time, of course, a very unconventional choice. Back then, a Supreme Court clerk could earn $600 or $700 a month in Los Angeles or Washington. In Phoenix, which was not yet the fifth largest city in the country, the going rate was $300 a month. William Rehnquist thought that his experience as a Supreme Court law clerk would allow him to demand a little bit more money, so he asked his firm for an extra $50 a month. They said no. But he nonetheless accepted the job. It was a very important lifestyle choice. Years later, Chief Justice Rehnquist would say that he instinctively appreciated the need to have a good balance between work and life. He noted that when you were young and impecunious, it was easy to trade your time for money, but as you grew older, it became harder and harder to trade it back. He told those of us entering the period when we might have a family that if you wanted to spend time with your young children, you had to do it when they were young. A characteristically Rehnquistian remark with a great kernel of truth in it. Anyway, 2 years later, William Rehnquist began work at an established, 2 years after he began work in Phoenix, he made another unconventional choice. He gave up the security of his law firm to open his own law firm with one other partner, the president of the local Young Democrats. William Rehnquist became a very successful litigator, although early on, as for most solo or single partnership practitioners, the going was rough, and he had to take whatever cases came his way, including the representation of many criminal defendants. Years later, someone from the law enforcement community would tell him that there was a wing at Leavenworth named after him in honor of his former clients. Now, in 1968, William Rehnquist received a call from Washington, D.C., asking if he would consider accepting the position of Assistant Attorney General for the Office of Legal Counsel. He did what any reasonable person would do after receiving such a call. He went to the local public library to determine what the, quote, Office of Legal Counsel was. Now, it turns out it was an important office in the Justice Department that gave constitutional advice to the Attorney General and the President. He made another choice and headed east with his family. The rest of the chief's history is more familiar to all of you. He was appointed to the Supreme Court in 1972 at the young age of 47. In his early years, he was a dissenting voice on the court. He was so often the lone dissenter that his law clerks bought him a Lone Ranger doll that stayed on his mantelpiece to the end of his tenure on the court and stayed there long after his lone dissents had become accepted as law by a majority of the court. In 1986, William Rehnquist was appointed Chief Justice. During his tenure, he earned the respect of his colleagues by the fairness and efficiency he displayed in carrying out his responsibilities as the Chief Justice. One of his colleagues, Justice Ruth Bader Ginsburg, called him the best boss she had ever had. I have not heard that she revised that opinion in recent years. Now, despite his high office, Rehnquist was totally unaffected by the pretense to which so many in Washington fall victim. For example, one year he missed the President's State of the Union address. His law clerks asked him, told him they would be looking forward to seeing him at the State of the Union, and he explained that he wasn't going to be there. Law clerk asked why. He said, "You have to go to the State of the Union address." He explained that it conflicted with the watercolor class he was taking at the local YMCA. Rehnquist explained that he had spent $25 to sign up for the class and he wasn't going to miss one of the sessions. Now, during Rehnquist's long tenure on the bench, I had the privilege of arguing 39 cases before him. Each of those arguments was a lesson, sometimes a hard one, in lawyering. As an associate justice, Rehnquist taught advocates the importance of preparation. That preparation focused on a rigorous understanding of the content of the controlling law. Any lawyer who made an argument before Justice Rehnquist and said what Congress meant in a particular statute was pulled up short by a question from Rehnquist. "You say that's what Congress meant. what did Congress say? Any lawyer stating an abstract proposition before the court would be met with what came to be the trademark Rehnquist question. Which of our cases supports that proposition? Now, whenever I'm asked by Chief Justice Rehnquist's enduring contributions, I focus on those two typical questions rather than on any particular area of the law. When Justice Rehnquist came onto the court, I think it's fair to say that the practice of constitutional law, how constitutional law was made, was more fluid and wide-ranging than it is today, more in the realm of political science. You can see that in the broader arguments that would be made in the briefs before the Supreme Court in important constitutional cases. Now, over Justice Rehnquist's time on the court, the method of analysis and argument shifted to the more solid grounds of legal arguments. What are the text of the statutes involved? What precedents control? Rehnquist, a student both of political science and the law, was significantly responsible for that seismic shift. Now, you can debate whether that was a good change or a bad change, and I had an interesting debate with some members of the faculty yesterday about just that question. But I think there's no disputing that such a shift did occur during the time that Justice Rehnquist was on the court. That's reflected in many things, but one barometer of the change from political science, public policy, to law, legal text, legal precedents, is the nature of the court itself. When Justice Rehnquist went on the court, a minority of the justices had been former federal judges. Today, for the first time in its history, every member of the court was a federal court of appeals judge before joining the court, a more legal perspective and less of a policy perspective. Now, as Chief Justice, William Rehnquist schooled lawyers on the importance of efficiency. In our court, lawyers are typically given 30 minutes to make their argument. The Chief Justice expected the lawyers to take no more than 30 minutes, and if a lawyer failed to come to a complete stop at the 30-minute mark, the Chief would issue a citation in the form of a stern admonition, "Thank you, counsel, your time has expired." No counsel, as far as I am aware, ever had the temerity to go beyond that announcement. The Chief Justice could get to the heart of a legal issue quickly and efficiently, and he expected the lawyers appearing before him to do the same. Chief Justice Rehnquist was also known for the brevity of his opinions. He had a keen sense of what issues were important and what issues could be left for another day. And when I go back and study his opinions in connection for my preparation for particular cases, I'm most impressed by what he chose not to say. The Supreme Court has the great luxury of discretionary jurisdiction, of being able to select what cases we will hear, what issues to decide, and when to decide them. Rehnquist had an experienced gardener's sense of ripeness and when to plant and when to weed. He understood the law as a functional discipline and did not waste his time with ornamental rootstock. There was an exception to this rule that you can see in his opinions, and it always delights the reader. Every now and then something would catch his historical fancy or his appetite for trivia, and you can find, for example, in an opinion about the statutory authority of the Postal Service, a long disquisition about the history of the Postal Service. If a particular case happened to involve a geographic area, you can find a discussion about the settlement of the area, or the altitude of the particular mountains, or why the river is pronounced differently in different parts of the state. Those detours are always pleasant for us going through the otherwise sparse legal analysis. As many of you know, the Chief Justice also chairs the Judicial Conference, a committee of 26 appellate judges who formulate the rules and policies for federal courts around the country. Justice Rehnquist brought to that conference his hallmark efficiency, streamlining discussions and quickly brokering consensus among the judges with often quite diverse views. One thing many of you may not know is that the Chief Justice is also the Chancellor of the Smithsonian Institution. That's a sprawling collection of museums not only in Washington but around the country. Rehnquist brought to that responsibility the same discipline as he brought to his judicial responsibilities. A significant part of the job of the Chief Justice, something that I didn't know about before I took the office, is what might be called the diplomatic responsibilities of the Chief Justice. The responsibility to meet with visiting delegations of judges and justices from around the country. More frequently these days, there are delegations of judges from countries that are trying to establish an independent judiciary. trying to develop the rule of law in countries that did not know that prior to their history. From studying Chief Justice Rehnquist's example in this area, I gleaned many significant insights, not only to how he approached that responsibility, but how he influenced the development of the rule of law around the country. Last year, a very distinguished Russian judge, Yuri Sidorenko, who was the chairman of the Council of Judges of the Russian Federation, visited the Supreme Court. I met with him, and he told me how he and Chief Justice Rehnquist had developed a close friendship, a friendship that to many would have seemed quite unlikely. The Russian judge and Rehnquist first met in 2002, and at that meeting, Rehnquist revealed his Swedish heritage. They soon fell into a discussion of the 1709 Battle of Poltava. Many of you may not know the details of that battle. But Justice Sidorenko and Chief Justice Rehnquist did. That was the battle where Peter the Great of Russia won a decisive victory through careful planning and perseverance over invading Swedish forces. It was the moment in history when the great northern power in Europe shifted from Sweden to Russia. A year later, when Justice Sidorenko reported in a letter to Chief Justice Rehnquist about the difficulties, the seemingly insurmountable difficulties he was having in promoting the rule of law in the face of resistance from other political elements in Russia, Chief Justice Rehnquist sent him a handwritten note with a simple statement on it: "Remember Poltava." Now, I later found out, after his visit with me, that Justice Sidorenko went to Arlington Cemetery to pay a private visit to Chief Justice Rehnquist's grave as a symbol of his appreciation for that support. Now, when friends of William Rehnquist gather, they often remember his distinctive personal traits, how he delighted in a good story in all things, charades, croquet, board games, and how he loved a vigorous swim or a good poker game. Now, if you hear these stories, you might view his distinctively unconventional personality as merely quirky, but you would be wrong to do that. Rehnquist was not unconventional in the manner of the two characters in a famous Thurber cartoon where the one asks the other, "Why can't you be a nonconformist like everyone else?" He was instead unconventional in the sense that Ralph Waldo Emerson described in his essay on self-reliance, an essay that Rehnquist enjoyed throughout his life. Emerson wrote, "Trust thyself, every heart vibrates to that iron string." And he went on in these words, "What I must do is all that concerns me, not what people think. This rule, equally arduous in actual and intellectual life, may serve for the whole distinction between greatness and meanness. It is the harder because you will always find those who think they know what is your duty better than you know it. It is easy in the world to live after the world's opinion. It is easy in solitude to live after our own. But the great man is he who in the midst of the crowd keeps with perfect sweetness the independence of solitude." Now, Chief Justice Rehnquist was unconventional because he internalized that very demanding standard. Perhaps no image of our former chief more poignantly captures his sense of duty than the picture we all saw 4 years ago. On January 20th, 2005, he walked down the steps of the inaugural platform with Sally Ryder close behind to administer the presidential oath of office. Chief Justice Rehnquist was at that time gravely ill, quietly battling a particularly virulent form of cancer. But the obligations of his office called, and he strode resolutely through the crowd of dignitaries, took his place at the podium shortly before noon, and discharged his responsibility with the same grit, determination, and independence that he brought to all matters that came before him. Now, that image, for many of us, evokes sadness at the time, for there was little doubt that Chief Justice Rehnquist was seriously ill. But today, in retrospect, it evokes respect. It stands as a vivid reminder that courage, mental toughness, and devotion to duty never go out of style. Those are the qualities that Chief Justice Rehnquist brought to the bench when deciding difficult issues. Now, if the Rehnquist Center follows his example and engages in determined and rigorous intellectual inquiry, unshackled from convention, it too will never go out of style. let me just add that the Rehnquist Center is off to a great start. The center has initiated wonderful public education and outreach efforts, which I saw firsthand during my visit to Tucson High School yesterday. The center is responding directly to the need of the local community to pass on to the next generation of leaders a solid understanding of the constitutional principles that have secured our freedom. The center's seminars and conferences are attracting distinguished scholars, present company accepted, to explore both timeless legal issues, such as judicial independence, federalism, and the separation of powers, and timely new topics, such as the effect of the new media on the law. It is vital to bring pragmatic intellectual forces to bear on these subjects, and the center provides an ideal forum for doing so. The center is also responding to Chief Justice's interest in exporting American rule of law principles to emerging democracies, a dedication encapsulated by the story of Chief Justice Sidorenko. The center's International Judicial Exchange program enables American and foreign lawyers and judges to engage in comparative analysis of their legal systems, understand their differences, and share solutions to common concerns. Chief Justice Rehnquist would surely embrace and applaud these efforts. I wish all of you in the center continued success in the years ahead. I've had a delightful visit here to Tucson, and thank you all very much for inviting me. Thank you. Thank you.
Question?
Sure. Thank you very much. Thanks. Thank you. Now, I'd be happy to take a few questions if anybody has any, and if I can, I'd be happy to give a few answers. Yes?
I noticed you mentioned exporting rule of law principles to other countries.
Oh, they want you to go to the microphone. So. The question began by saying I mentioned exporting American principles to other countries.
And I was wondering if other countries had a chance to speak with you about their principles. Do you read a lot of judicial opinions from overseas?
You know, we do have an exchange when these visiting delegations come to the United States. The bases for many of the principles of the different legal systems are quite distinct. We obviously share a heritage with the common law countries who developed their legal systems from England. The continental systems, for example, are quite different. And the notion of judicial independence, when you have judges playing a role that's at least partly akin to what we would call a prosecutor in developing the evidence before deciding, it's kind of hard to find common ground there. What's interesting with the delegations that visit these days is that they don't have either background. Since they're not experienced in democracy or the rule of law, it's not as if they're moving from one system, accepted system, to another. They're moving from one rubber stamp system to one where the judges are going to do more than just rubber stamp the executive or legislative decisions that come before them. And you have to understand, when we're talking about judicial independence, the authority of our judges building on centuries of power and interpreting legal documents and the other branches following that, the risks we face are nothing like the risk they face. I meet with judges and justices who, if they issue a particular decision, are quite likely to end up in jail or worse. And yet they come to our Supreme Court because they view it as an icon of what they're trying to achieve in their countries. The experience has left me with a profound new appreciation for what we have in this country and a commitment to make sure that we don't compromise that in any way. Who's next?
Justice Roberts, you spoke about the shift from policy perspectives to legal perspectives on the court, and now the court is made up of members of former appellate judges. Can you speak to the effect of the lack of trial experience from the justices and perhaps even the clerks that you work with?
Yeah, I think it's the word, I think it's an unfortunate circumstance. I think it's a flaw. I think it would be good for the court. I'm not in the business of selecting future members of the court. I think it would be a good thing, if possible, that that person have some trial experience. It's an interesting thing about our court, that it's very diverse in terms of the experiences people bring to the court. We have people with primarily an academic background who can bring a scholarly perspective. We have, for example, in Justice Souter, someone who spent most of his career prior to joining the court in the state legal system, both as the Attorney General and on the state court. We have in Justice Thomas, someone who spent a significant amount of his professional career running an agency. We have in Justice Breyer, someone who spent a good part of his time before becoming a judge working in the Judiciary Committee in the legislative branch. And all those, with Justice Stevens and Justice Kennedy, we have people who had significant practice careers before joining the bench. I hope I also bring something of that perspective. I was a judge in the Court of Appeals for only 2 years. Most of my experience in this area came from being a practitioner. I think you're quite right that the one gaping hole in the background of legal experience is a trial experience, a trial judge. Chief Justice Rehnquist was a hands-on trial lawyer for his entire career as a private practitioner. And he missed that. And I know he used to say, as the appellate judges were reviewing a transcript, that that's not how he viewed the way a deposition transcript should be looked at, because he had spent a lot of time conducting depositions. He missed the trial stuff so much that when he was Chief Justice, he appointed himself to sit as a trial judge in the Eastern District of Virginia during one of the court's recesses. And he heard a case and issued the opinion, and was promptly reversed by the Fourth Circuit. So his only comment as he read the Fourth Circuit's per curiam decision was that they didn't have the guts to put one of their names to it. But partly because of that, I can assure you I'm not going to appoint myself to a trial bench. But it's a good point. Yeah. I know. We should have put mics in the back there.
Justice Roberts, I'm not an attorney. I'm trying to get into law school here. And as you can tell, I'm a little bit older than your average student. And I have the question that I've been researching is how do we bring enemy combatants into the country and then try them in civilian courts? What rule of law? Where in the Constitution? It's an issue that we bring up, we talk about all the time. I don't want to talk about the politics of it, but more so, how does it work? How does this work within the confines of the Constitution?
Yeah, no, I mean, I appreciate the question. It's a serious issue. Because of the constraints of my office, I think most people recognize it's one I really can't comment on. We have had several decisions involving the issue of the status of enemy combatants, whether in foreign battlefields, in Guantanamo, or here. We have issues coming up and cases scheduled, and I can't comment publicly on that question at all. Sorry. Yes?
Thank you, Chief Justice. It's a wonderful speech. Just kind of going back to what you were talking about with the trial court, you're the highest court in the U.S., and you're making decisions every day that affect all of our lives. How do you keep yourself aware of the people that these cases are about? I mean, the court needs to hear a case or controversy, and there has to be some sort of injury. There has to be people involved. What kind of steps do you take that let you look at the actual people whose lives you deal with on a daily basis?
Well, you know, I'm not sure what level your question is directed, but at the one level, you know, there are people involved, and they're going to be affected. They're going to be affected in a very serious way. You can see that obviously in the range of cases. You have a capital case, obviously someone's life is going to be affected very directly, but also in the business cases, the civil rights cases, and you need to take that into account to understand the real world impact of your decision. On the other hand, those of us who take the judicial oath, which is different from the oath that every federal employee takes, one of the things we swear to do is administer justice without respect to persons. It's an interesting phraseology. And given what the framers were concerned about, it's without respect to persons equally, I got the words right, equally for the poor and the rich, which was the main concern at the time. They weren't worried about, equally with respect to racial identity or ethnic. They were worried about rich and poor, so they spelled that out in the judicial oath. So to one extent, yes, you need to know the real-world impact of your decisions, and that's often a factor in determining what did Congress mean. And if the impact strikes you as unlikely, that's certainly something you take into account. But the fact that the person bringing the suit is of a particular individual, of a particular background or anything else, the courts are supposed to be blind. I mean, that's why the statue of justice, you see balancing the scales, has a blindfold on her. Because the idea is you don't know who the people are. You're just deciding the case according to the law. Always somebody in the back. That's the
Chief Justice, I just had a question. What skill set would you say that the Chief Justice must possess over the other justices of the Supreme Court in administrating their duties?
Well, it's one area. People ask me what surprised you most about the job, and I would say it's the extent of the administrative duties. The budget responsibilities, the budget not only for the Supreme Court, but for the entire judiciary, presenting to Congress in some way the issues of great concern to the judges around the country, dealing with basic administrative questions through the Judicial Conference that affect the local courts, even to the minutiae of what type of computer systems, how they can be shared between particular courts, all sorts of things like that. The one thing I know is that I was not selected for this job because of my skill in handling administrative matters. I was not interested in the job because of my keen interest in handling administrative matters. They kind of just come with the territory. I have wonderful people to help me with them. I hope I get better at them as I go along. I mean, a lot of these things I'm coming to them for the first time. It's the first time I've had to, address a budget issue. It's the first time I've had to address Judicial Conference issues about the construction of new courthouses or things like that, and it takes me a little longer. I'm hopeful that as time goes on, it'll be less and less of a percentage of my time. It was the one, and there's also, as I mentioned, I mean, the kind of extracurricular activities. However unqualified you may think I am for administrative matters, I think we can all agree I was totally unqualified to be the Chancellor of the Smithsonian Institution. I know my colleagues on the Board of Regents would be happy to agree with that, but it kind of comes with the territory, and you try to make the best of it that you can. Yeah.
I had a question that kind of dovetails into your last response. Something I've noticed here just in Arizona with the budget shortfalls, I mean, some prosecutions aren't occurring. They're talking about revising sentencing guidelines. Mm-hmm. Do you see that, I mean, the nationwide budget shortfall having any impact just on the administration of justice? I mean, because for the near future, this is what we're looking at.
Sure. Now, we actually, the judiciary, over the past few years, has done pretty well in the budget process. But we have significant needs, whether it's courthouse construction, modernization. At the Supreme Court itself, for example, we're going through the first renovation in the building's 70 years. As you might imagine, 70 years ago, you didn't have a great need for wiring and things like that. The availability of telephones was a major breakthrough at that time. The same is true for courthouses around the country and how we accommodate technology. I had a visit up to Canada. This learning about judicial systems goes both ways, and they had a state-of-the-art jury box with, everybody could have their own little, I don't know what they are, laptop screens or something, when the lawyers, as they increasingly do, were presenting video evidence or depictions, and they could all look at it. They had translation things, because they have both English and French up there. And there are a lot of areas where we have similar needs, and those, like everything else, they cost a lot of money. So yeah, it's significant. We're doing our best right now to explain how all of these things are shovel-ready infrastructure projects. But all the other agencies and whatnot in Washington are doing the same thing. Yes.
Good morning.
Hi.
You've mentioned a couple of times the independence of the judiciary, that being one of your priorities, one of the court's priorities. It seems to me that the increasingly politicized nature of the judicial confirmation process is a significant threat to the independence of the judiciary. So my question is, what suggestions, if any, would you have for depoliticizing that process in some way? It seems entirely likely that in the next several years an opening on the Supreme Court will occur. Certainly there will be openings on the federal appellate courts, as there currently are. So how can that process remain transparent and yet also be less politicized than it currently is?
Well, I mean, it's a great question. I do think you're right that the courts as a whole are very concerned about partisanship, politicization, seeping into the judicial branch. Commentators on Washington have explained how, you know, the Congress used to be a very different place than it is today, that you had a more civil interchange, that the lines were not as sharply drawn. That has naturally affected how members of the Senate, for example, in the confirmation process, view their responsibilities. And I think it would be a very bad thing to have that change take place in the judiciary. And you're right, one of the great contact points between those two things, that is the Senate confirmation process. I thought during my process, you know, I was treated quite fairly, and I was very pleased to have, you know, significant support from both sides of the aisle. But that's not always the case. And what do we do about it? I think we need to have a broader recognition in our co-equal branch that we are not part of the political process, that we are not representatives of either an administration or a confirming Senate on the court. Your perspective, my colleagues told me this, and it's quite right, your perspective on everything changes the moment you take the judicial oath. You literally move from a branch in which many of us had been active in one way or another to a different place. And the framers were sensitive to that. They set up a system where that would take place. I mean, just the fact that we don't stand for election, we can't be thrown out of, you know, the impeachment process, you know, is not a serious limitation on disagreement. That principle was established early on, that simply because the legislative branch disagrees with the decision of the courts, that's not a ground for impeachment. So the transformation is quite sharp. It certainly develops over time. Justice Stevens, who's been on the court for 30 years, I'm sure feels no remote allegiance to the policies of the Ford administration. You know, President Ford appointed him. He retains, I think, a special, you know, place in his heart, as we all do, for the president who appointed them. But the idea that we're a political representative just can't persist given the framers' plan. But it is a danger. I mean, I think, for example, this was a point that I had a lot of discussion with the members of the Judiciary Committee on. You know, judges, justices really can't tell them how we're going to vote in a particular case. We are not their agents. They don't have a laundry list. They can say, all right, here are the things that are of interest to my constituents. You know, you agree with me on this. Now go forth and implement it. And that's why throughout the spectrum of folks who've come on the court, I mean, I was happy to invoke, you know, the Ginsburg rule, because that's how Justice Ginsburg approached those questions. You know, I hope somebody from whatever political perspective, they were going to be able to invoke the Roberts rule, the Ginsburg rule. And one sentiment that was communicated to me from my colleagues, that they were very glad that I hadn't compromised myself by appearing to agree or forecast how I would vote in particular cases. The judiciary as a whole is very committed to avoiding that type of partisanship. The best way for us to show it is in our opinions and to make clear that they represent considered legal analysis without any type of partisan edge. It's an important distinguishing characteristic of our branch. You know, the other branches stand for election. People can throw them out. If we do something that people don't like, it's just kind of too bad. They can't throw us out. Which is why when the president does something, he doesn't have to issue an explanation saying, this is why I've taken a particular action. When the legislature passes a law, they don't have to explain to you why they're doing it. They usually do. They have press releases or speeches, but they don't have to. Because nobody elects us, because nobody can throw us out, we have to explain it. Here's why we're doing something that is going to affect your lives every bit as much as what the president does and what the legislature does. Here's why we're doing it. And the great advantage, all of you who are law students, all of you who are law professors, those of you who are neither but are interested in public affairs, you can look at it. And you can make your own judgment about whether or not this holds together. Is this an analysis of the law? Whether you agree with it or not, is it legal? Or is it political? Whether you agree with it or not. And that's the real test of whether or not we're doing what we should do to keep politics and the sharp partisanship out of our deliberations. One thing I can say is in my time on the court, I've never seen any evidence that people approach these questions in political terms. Our discussion in the conference room is purely legal. The analysis in our opinions and memos and drafts is purely legal. No one suggests, oh, you're doing that because you came from a particular political party or were appointed by a particular president. Analysts and scholars often say something like that, and it's up to them if they want to articulate that to defend it. It's simply not how we do business. Thanks.
This may be a simple question, but as a law student, I read a lot of opinions, and I was wondering the process that you go through to decide which justices might write which opinions.
It's a fascinating process. It's one of the more intricate parts of my job that I have to do. First thing I do is, obviously I only get to do it when I'm in the majority. I hope that's more often than not. I look at efficiency. If we have a judge, or a justice who's behind in his or her work, I may not give them an opinion that sitting, or I might give them an easy opinion in that sitting to make sure we get things done on time. Part of my job is to make sure the trains run on time, so that's a big part of it. Part of it is a mix. I can't give somebody all the good opinions, even myself, and somebody all the bad ones, which we call the dogs. I have to take my fair share of those, and everybody else does. I would hope at the end of the year, if you drew a list up of these are the 12 most interesting cases, that there'll be 9 justices along those, and here are the 12 worst ones, that those same 9 will be distributed there. I try to make sure there's a distribution of substance. I don't want anybody just writing criminal cases all year long, even if they're interested in that. I try to make sure we remain a generalist court. I try to give a mix of divided and consensus cases. If we're 9-0 on, somebody shouldn't have a 9-0 case one month, a 9-0 case the next month, a 9-0 case the next month. They've got to do their share of back and forth in the divided cases. Those are kind of all the considerations that go into it. It's not easy. I like to liken it to, I don't know if people do these, one of those Rubik's Cubes. Everything has to sort of fall in shape to get it perfect. And it doesn't always do that, but it's an interesting part. And one of the more significant things I do is jurisprudential. You have 2 justices in the majority, and one is interested in writing a broad opinion that 5 justices are going to sign on to, and the other is interested in writing a narrow opinion that 8 or 9 justices are going to sign on to. I'm more likely to assign it to the latter justice than the former, because I think that's the way that the law ought to proceed. And the other justice can write a concurring opinion saying, we should do this more broadly, or whatnot. So there's a lot of factors that go into it. And I'm not always satisfied with how I've balanced them, but those are the sort of things I look at. Hello.
Hello. You're very much at the beginning of your tenure on the court.
And I hope so.
Yeah. As you look out into the future and as you think about, what you want to leave with the court, what are your goals and what is your legacy that you'd like to leave?
Well, you know, I was asked that question at my confirmation hearings, and my answer is the same. I hope people would look back on my tenure and say that he was a good judge. That encompasses so many different things. You know, it encompasses fairness, an ability to decide cases without regard to persons, without regard to politics. I would hope, as my predecessor, William Rehnquist, was regarded, that I was a fair Chief Justice in terms of my relationship with my colleagues. You know, in any human endeavor, you're going to make mistakes. You're going to do things that are not as good as you wish you could have done it when you look back on them. But as Chief Justice Rehnquist always said, you know, you do the best you can, and then you move on. And that's how I approach every case, all the administrative issues with which I'm confronted. And if at the end of that time people of all persuasions can look back and say, you know, he was a good judge, I will feel that that was a life well spent. Thank you.